Mr. Webster.
Mr. Mitchell, actually, my lady.
Oh, I'm terribly sorry.
Not at all. There are two silks on this side of the case,
Yes.
and I'm sure it isn't possible on the note that you've got to determine which one is leading. As it happens, I'm leading today. So, as you now know, I appear in this matter for the appellant with Mr. Webster. For the respondent, we've got Mr. Bishop and Mr. Speaker, both King's Counsel, and Mr. Sear, who sits behind me.
Sorry, I haven't got a note of Mr. Speaker, so thank you. Right. Thank you.
Thank you, my lady. Could I begin with a couple of housekeeping matters?
Yes, please.
Thank you very much indeed. The first concerns the authorities bundle. 2 points to be made in relation to that. The first is this. You should have two authorities bundles.
We do?
Thank you. One rather fuller than the other, I'm afraid. The thin authorities bundle is for the ancillary application. It shouldn't be necessary to look at that at all until this afternoon.
No.
But for completeness, can I just confirm that the court received yesterday an updated authorities bundle with two additional authorities inserted, Ladden Marshall and INRI E?
Well, we did electronically.
We can certainly arrange...
We've got them, thank you.
Marvellous.
They've been put into a separate bundle.
Thank you. Well, I'm most grateful to you.
But we saw the electronic editions.
Thank you. The second is in connection with the main authorities bundle. Now, we had some issues with producing the highlighted copy of that bundle, and I believe what that meant was that the court was initially sent unhighlighted authorities. Obviously, I apologise for that. There still appears to be some issues with the highlighting, so I'm afraid I will refer to sections in the authorities at some point, or may refer to sections in the authorities at some point, which are not highlighted, and I do apologise to everybody.
I'm sure we'll cope.
I'm most grateful. Thank you very much. The second is a slightly meatier housekeeping point, and it concerns the issue of confidentiality, which you will see has been present in this case for a number of years now. The result of earlier confidentiality is that there is a difference between the final judgment of Sir Jonathan Cohen and that which is published on Bailey. And I think it's sensible, if I may, at this juncture, just to flag up those paragraphs that are different. I don't, as it happens, anticipate that we are likely to focus on those paragraphs, certainly in the course of the first part of this appeal. But just in case we do stray onto it, I think it's probably useful for us all just to proceed with caution. So I'm very willing to be corrected by other people in this court, but as I understand it, the differences are to paragraphs 41 to 48 inclusive.
So these were not made public?
They're not there in their entirety.
Well, wouldn't it be better for us to receive the judgment that went on to Bailey in order that we have that, as well as these references now?
Of course. I'll arrange for that to be... Oh, marvellous.
Thank you very much.
I have copies of the judgment with the redaction showing.
May we have them now, then, please? You've seen this, have you, Mr. Mitchell?
As it happens, I haven't, but I'm... Thanks very much.
Thank you very much.
It wasn't allowed, it's not at the time that the judgment was handed down.
Right, thank you.
So let me just... So I said 41 to 48.
Yes, we see that there's lines through.
Yes. And then I said 82. Now the difficulty is that the numbers don't align, so I've taken this. Can I suggest that instead of me wasting time on this now, I just ask Mr. Webster if he could quickly have a look through, and if there are any points that he thinks that I should raise with the court, I'll do it at an appropriate moment.
Yes, certainly this document that's just been handed up has shown in it lines through certain paragraphs or parts of paragraphs, which we are to assume were with the final judgment, and at the behest of the judge once he determined the application?
Yes, I'm not convinced, comparing this document now quickly with my knowledge of the document that you find in tab 4 of the bundle, that they are directly comparable. So, but rather than waste time going through it paragraph by paragraph, I wonder if I could ask Mr. Webster if he can just satisfy himself as to the position. If there's any points, I'll raise them. Otherwise, it's useful to have this document. We're not going to get onto those paragraphs, certainly in the first part of my presentation, and I don't anticipate at all this morning. I think the paragraphs that are relevant to redaction are much more for discussion this afternoon at 3 o'clock. Thank you very much indeed. Thank you. So, subject to those housekeeping points then, as you know, this is an appeal against an order made by Sir Jonathan Cohen on the 3rd of February 2022, by which he ordered the husband to pay the wife an additional £1.1 million, a sum of money which he assessed on the basis of its sufficiency to meet the wife's needs as he saw it. For what it's worth, and standing back to look at the overall matrimonial asset sheet as at that date, that affected a division, a percentage division of 91% of the assets to the husband and 9% to the wife.
On the then valuation?
That's right, on the assets that were before Sir Jonathan.
In 2021?
January 2022.
2022?
Yes, yes. This appeal really engages a single issue, and it's that issue that we identify in our skeleton argument, which is, should a person who has obtained an order, or two orders in this case, through fraud, be entitled nonetheless to benefit from their fraud, A, by contending for and securing the application in their favour of the principle set out in Kingdon, and or by beneficial reliance on the earlier tainted orders, or at all. Now, as it happens, Lady Justice King, giving permission, phrased the question a slightly different way. She says this appeal gives the court an opportunity to consider the role of Kingdon and how to approach a case where, on the one hand, the increase in value of the company is not part of the marital request, but on the other, the reason the court is seized with the matter many years post-separation is as a consequence of the husband's willful non-disclosure. It is probably helpful for the court to know at this juncture that there are no authorities that I know of that deal directly with these points in the context of financial remedy proceedings, save perhaps for Kingdon itself. And Lord Justice Wilson, giving the lead judgment in that case, makes the point that there is a dearth of authorities on the point. Because of the nature of this appeal, we say the court is going to have to consider not only the specific facts and circumstances of this case, but also the court's duty to protect the integrity of its processes and ensure a fair trial, and the established public policy of discouraging fraud. And perhaps the starting point for us to consider that is just by considering the basic rights that are engaged in family proceedings when a person issues an originating application. So in this case, my client issued her Form A, the originating application, in 2010. From that point on, the overriding objective is engaged. That's the objective in Rule 1.1 of the Family Procedure Rules, as I'm sure the court is aware. And that means the case could be dealt with justly, expeditiously and fairly, and ensuring that the parties are on an equal footing. Now, in the submissions which the respondent made in response to our application for permission to appeal, they made an assertion about the bedrock of the modern law of financial remedies. That document is at page 65 of the core bundle at tab 6. And it's paragraph 2 of that document, in which they describe the bedrock of the modern law of financial remedies being the three bases on which entitlement to financial relief arises when the court is applying Section 25 of the Matrimonial Causes Act 1973 in order to achieve a fair outcome. And those bases are sharing, needs, and compensation. With respect to my learned friends, that is not, in our submission, an accurate statement of the law. the bedrock of the modern law of financial remedies is the duty of full and frank disclosure. The concepts that are enunciated by my learned friends that I've just read to you, needs, compensation and sharing, are not the bedrock of the modern law of ancillary relief. They are the rationales which the House of Lords identifies in the judgment in Miller as justifying a redistribution of family wealth on the breakdown of a marriage.
There isn't a single bedrock, it's a part of the bedrock.
Well, they're the three principles, is how I would put it, my lady, but yes. But the whole edifice is built upon the duty of full and frank disclosure.
Well, does anybody take any issue with that? Mr. Bishop?
No.
No? There we go.
No. Well, I'm grateful to him for indicating that. For what it's worth, the bedrock is spelt out by Lady Hale, citing from the House of Lords in Livesey and Jenkins in her judgment in Charland at page 225 of the authorities bundle. As is so often the case in this area, the most beautiful quote to enunciate what is being talked about comes from Mr. Justice Mostyn. And in a case, it's not in the bundle because the principle is not controversial.
Well, we will not deal with it then if it's
Very,
not
very
in the
good.
bundle.
Very, very good. It is clear, beyond doubt, we say, that the respondent had deprived the appellant of her fair trial rights prior to the hearing before Sir Jonathan Cohen. That much is acknowledged by Mr. Justice Holman at page, in his judgment, which one finds at page 100 of the supplementary bundle.
This is the set-aside judgment.
This is the set-aside judgment in which Mr. Justice Holman says, from the perspective of the wife, I enormously regret that outcome, that is to say the outcome that the order must be set aside. It is now 10 years since the parties separated, and she continues to battle for a just resolution of her claims based on openness and full and frank disclosure. So it must follow from that she had not received a just resolution of her claims based on openness and full and frank disclosure prior to that. Now, interestingly, given his approach to the case, Sir Jonathan Cohen also acknowledges that in the core bundle, page 57, in his judgment.
My lady doesn't have the supplemental bundle, and it's necessary for her.
It certainly is, yes.
The back of the core bundle.
I've looked at the back of the core bundle.
Well, the Holman judgment I was just referring to is...
I've got that. There isn't a separate one, is it? It is simply the one at the back.
Yes, it should be.
Enough. Thank you. Right.
I've got my core bundle separated into
fine.
supplemental
Thank you.
as well.
Oh,
My apologies.
Yes.
Yeah.
Yes, Sir Jonathan Cohen, interestingly enough, acknowledges that in his own judgment at paragraph 78, which you find at page 57 of the core bundle. He says, correctly in our submission, my starting point is that I am adjudicating upon the wife's claim de novo, albeit against the background of the orders made in the past which have provided her with funds. I am acutely aware of the criticisms made by the courts in the past of the husband's disclosure, which has deprived the wife of the opportunity of being able to consider the resolution of her claims with full knowledge of what the asset base was. Now, given that acknowledgement by Sir Jonathan, we say it is startling that he then went on and deprived her of the opportunity as we would characterise it, but we'll come on to that later on. There should not be scope for any debate about this, and I don't anticipate that there will be, but it's perhaps worth making this point. The general legal principles applicable in the courts are no less applicable in the family division than they are elsewhere. And authority for that proposition, not in the bundle, but it is in our skeleton, and we agreed that the authority would not be included.
But if it's an agreed authority, it doesn't need to go in
No,
the
I know.
bundle.
I know.
So where do we find it in your skeleton?
It's where we refer to Preston Petridel. Hang on a second, I'll tell you exactly where it is in the skeleton. Where is it, Simon? Page 71 of the bundle.
Thank you.
Right, so right at the beginning. And in actual fact,
Is it at page?
No, what we say is it tends against recent high authority. The effective family division is not a legal island with its own laws and principles, and we quote the authority for that. We don't quote the quote. The quote is short, and I'll read it to you now. Lord Sumption said, "Courts exercising family jurisdiction do not occupy a desert island in which general legal concepts are suspended or mean something different."
Yeah,
And for your note,
we're
that's
aware of that, yes.
paragraph 37 of his judgment in that case. We say that those principles include the general public policy that reasonable steps are taken by the court to protect its procedures from fraud and those who are victims of fraud. Again, that is confirmed in our submission by Lady Hale herself in Sharland, page 227 of the authorities bundle. And it's worth just having a quick look at that now, if we may. And I'm afraid in a page bereft of highlighting, for which I apologise, I'm looking at paragraph 32. She identifies about halfway through that paragraph that Sharland was a case of fraud, and makes the point that it would be extraordinary if the victim of a fraudulent misrepresentation which had led her to compromise her claim to financial remedies in a matrimonial case were in a worse position than the victim of a fraudulent misrepresentation in an ordinary contract case. She then goes on, furthermore, the court is in no position to protect the victim from the deception or to conduct its statutory duties properly because the court too has been deceived. And then she commends Lord Justice Briggs's first reason that he gave in his dissenting judgment sitting in this court when he said that he would have allowed the appeal.
Yes, I was in it. You'll know.
I recall, my lady. I too. Having made those general introductions, perhaps I can go on and just set out in a little more detail than is in our skeleton the frauds that have occurred in this case. The first fraud is characterised as a failure by the husband to disclose his true interest in the Hardy and Eagle trusts. And to see that in paper, one has to look first at the husband's disclosure prior to the making of the consent order. And one finds that in the supplementary appeal bundle.
Can I just ask whether it's necessary for us to go to that detail? We are obliged to proceed on the basis, and do so, that on 2 occasions the respondent husband has been found to have made inadequate, to put it mildly, disclosure. And we know what happened both in 2010 and 2016 and what's happened now to bring this matter before the court.
Of course. I certainly...
If there's another reason to take us there, we'll gladly go, but I just wonder why you're doing it.
The answer is because when we get to Kingdon, as you will see, Lord Justice Wilson in that case says that a highly relevant factor to consider when considering whether or not to exercise the Kingdon jurisdiction is the turpitude of the perpetrator of the fraud. And for that reason, I would like to just...
So be it.
Thank you. I'm most grateful.
What is the point? Degrees of turpitude, is that the point?
Yes,
Right.
because it's my submission that this court needs properly to understand the nature of these frauds. So, and I'll deal with this as shortly as I can, in advance of the court approving the consent order in 2010, the parties are obliged to submit documents setting out their financial resources. And those are summary documents, which in the wife's case is at tab 2 of the supplementary bundle, and in the husband's at tab 3. It's the husband's that we need to look at.
Right. When you're taking us to the supplementary bundle,
Yes.
I wonder if you'd be ever so kind to bear in mind that, first of all, my lady is looking at her bundle without the reference to it being a supplementary
Yes.
bundle at all, and I have not been provided with a tabbed. So we will need to
Page numbers.
yes, go to page numbers, and you'll have to bear with us so that we can follow you.
Of course. Thank
All
you.
right.
Yes, of course. Absolutely.
So when you say tab 3, what's the page number?
Page 9.
Right. So this is the husband's disclosure.
Yes. The form itself starts on page 7, but he exhibited this document to it. It's relevant also for the arithmetic, but I don't think we need to go into that at this particular stage.
No, we're looking at principles.
Yes, absolutely. So you'll see there lines 12 and 13, trust interests. The husband described himself as a potential beneficiary of the Hardy Trust and the Eagle Trust. And I should make a further point at this juncture because it's highly relevant. This document was prepared on behalf of the husband by a gentleman called Mr. O'Donnell, who was at that time, and continued to be afterwards, in actual fact, the party's accountant.
Joint accountant.
He was a joint accountant, yes.
Right, okay.
And the relevance of that will be explained in a moment. Just reading on, and one doesn't need to look at the details of this, you've got the summary document at page 9, and then at page 13,
Right.
curiously in landscape mode for some reason, is a valuation that was prepared by Mr. O'Donnell of the husband's business assets as at that time. We don't need to look at the detail of that, but I just flag it up so that the court knows that it is there. Now, as you know, the matter came in front of Mr. Justice Moore on set-aside, and he made some pretty trenchant findings against the husband, and, we say this is relevant, against the credibility of Mr. O'Donnell. So now moving on through the supplementary bundle to page 35, please. I flag up, but don't need to read in any detail, Mr. Justice Moore's assessment of the husband, and you'll see there in paragraph 66 that he finds that the husband did not tell him the truth. We then have, crucially, Mr. Justice Moore's assessment of Mr. O'Donnell, and for obvious reasons, my client's retainer of him as her accountant did not survive this assessment. So on that page 36, Mr. Justice Moore lays bare the fiction that under which my client up until that point was labouring, that Mr. O'Donnell was a neutral third party, assisting them both on neutral terms. As he says in paragraph 70, it is abundantly clear he was approaching this negotiation very much from the viewpoint of the husband. He acted as an apologist for the husband, and at that time did not ensure that the husband complied with his duty of full and frank disclosure. And later on, he finds that Mr. O'Donnell was economical with the truth and gave answers designed to mislead the wife, down at the bottom of paragraph 74.
Can you direct me to the... Oh, there it is.
Yes.
The apologist.
Yes.
Thank you.
Starting at the bottom of page 37, paragraph 81, we have Mr. Justice Moore's findings about the disclosure. He finds that the initial letter from the husband's then solicitors Burgess Salmon was not, as the husband maintained, muddled, but was completely false. he finds other intentional mistakes, paragraphs 81, 82, 83 and 84. I need not read them. And then reminds himself that the wife and her advisors had virtually no time to consider the disclosure. Further relevant comments about the husband's state of mind, paragraphs 87 and 88. So at the time the husband said he was a potential beneficiary only in those trusts, he found that the Eagle and Hardy trusts contained £4.2 million in cash. I do not know the value of the remaining Toolstation shares, but even if the 2008 figures were used, the value ascribed would have been around £3 million. I find the husband knew there was £4.2 million in the trusts in May 2010, and on the balance of probabilities, I find this was the reason that full and frank disclosure was not given. And the full and frank disclosure, of course, would have been that the husband was in actual fact the primary beneficiary of those trusts and was in a position to call for the money in them at any time.
And these findings, which were subject potentially to applications for permission to appeal, were all turned down.
Yes.
The applications were turned down,
Yes.
the findings stand.
Yes, that's right.
Yes.
That's right. At that stage, of course, there was the right to renew an application. So there was an application on paper that was turned down by Lady Justice King, and then an oral application by Lady Justice King.
Yes, I've seen.
Yes, yes. Now, these findings go not only to the existence of very valuable additional assets, they go to the credibility of the presentation made to the wife at that time by Mr. O'Donnell. That presentation, of course, crucially included the value for the business assets by somebody who was presenting himself as a neutral third party, but who was in actual fact acting to present the husband's best interests. Now, the second fraud is different, but in our submission has all the same hallmarks of the first fraud. So, when the matter came back before Mr. Justice Moylan in 2016, he directed that there should be a valuation of the husband's business assets, both at 2010 and at 2016. And a report was commissioned from an accountant, Mr. David Green. He concluded that as at 2016, the value of the husband's business assets was 19.72, the value of the whole company was £19.72 million, and the husband's 81.82% share was £16.14 million. Now, in the course of that application, the husband disclosed that he had been approached by somebody wanting to buy the company. It was called the conditional offer. And he disclosed that that offer was £82.6 million. That would have given the husband £67.6 million. Inevitably, Mr. Justice Moylan had to consider the relevance, if any, of that offer. And I should have said Mr. Justice Moylan and the accountant David Green had to consider the relevance of that offer. I'm sorry, I'm being reminded that the husband didn't voluntarily disclose that offer. It was discovered by my client and he then disclosed it. Now, in relation to that offer, the husband gave some evidence, and the finding in relation to that evidence is reported at paragraph 63 of the judgment of Mr. Justice Moylan at page 55.
Thank you.
Familiar to that?
Supplementary bundle.
Does my lady have that? Thank you. The husband commented in his oral evidence that the offer was so highly caveated that it was never a realistic offer in the sense of being achievable. And the judge then agrees with the accountant, who on the basis of that representation by the husband had considered that the offer was of no relevance to the exercise because it did not reflect the likely value of the business. Now, that evidence was in actual fact shockingly untrue, as is revealed by the findings of Mr. Justice Holman.
The husband's evidence.
The husband's,
Accountant's.
of course not the accountant's. No, I'm so sorry. The husband's evidence, upon which the accountant based his conclusions,
Yes.
and upon which Mr. Justice Moylan based his finding. And it's perhaps relevant at this juncture to say that Mr. Justice Moylan had also concluded that he was being told the truth by the husband. He found his evidence to be largely reliable, and that's at paragraph 39 of the judgment on page 51.
Mr. Green, just remind me, was he a single joint expert?
Yes, he was, my lady. Yes.
Thank you.
Page 91 of the core bundle, then, we have Mr. Justice Holman's findings about the truth of what was going on at that time. And it's at the top of page 91. I'm so sorry. I'm so sorry. It's supplemental bundle. I'm so sorry. Forgive me. Thank you.
Do we need actually to start at 90?
Well,
Because he refers
yes,
to the
you're
earlier
right.
negotiations.
Yes, you're right.
Which Moylan J had described in paragraphs 61 to 63, which you've taken us to.
Yes. The relevant finding, however, is that contrary to the impression that the husband had sought to give in relation to that offer, that it was heavily caveated and would never follow through to deal, contrary to that, in actual fact, as one of the directors of the company purchasing it said in his evidence, the offer was not formally withdrawn. It petered out because it was not high enough for the husband and was not accepted. And elsewhere, Mr. Justice Holman reports or makes findings about the extent of ongoing negotiations that continued up until the day before Mr. Justice Moylan gave his judgment. And on that day, an offer was made by the husband in relation to the company. And that offer was for £25 million for a 25% share. So in actual fact, selling only 25% of his shares was going to yield for him more money than the single joint expert accountant believed the entire business to be worth at that time. Now, the husband said nothing about this. And in so doing, of course, we say, deprived the wife of an opportunity to explore the true position, the accountant the opportunity to consider the true position, and Mr. Justice Moylan an opportunity to consider what the outcome should be in light of that development. So we now have an undermined accountant's valuation and an undermined finding by Mr. Justice Moylan that the husband's evidence was largely reliable. Now, the reason I've taken you to the nature of these frauds is to make the following submissions. We say, when the court has to consider the turpitude of the husband's conduct, that these were calculated and sustained frauds. They were specifically intended to mislead the wife and the court. And they did mislead the wife and, crucially, the court, thus making it impossible for the court to undertake its statutory duty. The turpitude went further than that, however, because it is clear, both from the findings of Mr. Justice Moore in relation to Mr. O'Donnell and the evidence that was given to Mr. Justice Holman that the husband involved third parties in his fraud.
Who was the third party in the second fraud?
It was a director of both the husband's company and the company that was looking to buy the husband's company, who was specifically asked to put nothing in writing because of his ongoing divorce proceedings.
So,
Was that Mr. X? Yes, referred to in the proceedings as Mr. X.
yes.
Lady.
Because the judge refers to 3 witnesses and X.
Yes,
is the third.
yes.
So it is Mr. X.
It is Mr. X, yes.
So your submission is that it was clear from the findings, both of Mr. Justice Moore and Mr. Justice Holman,
Yeah.
that not only had the husband embarked upon this disreputable behaviour, but he had actively recruited and persuaded 2 others.
Yes, yes.
And that view, knowing that the matter was before the court.
Yes, but it goes. So in the case of Mr. X, it was an active attempt to conceal evidence or a possible paper trail, so that any order for disclosure would not reveal the truth. And in relation to Mr. O'Donnell, it was an attempt to clothe his disclosure with respectability in the eyes of the wife, but in actual fact it could not bear upon scrutiny.
And it was Mr. X, together with Darrell Morris and Mark Norton, who Holman J, paragraph 26, described as wholly honest witnesses.
Yes.
Each doing their best, truthfully
Yes.
and reliably.
Yes, that's right. They didn't, if I can put it in this colloquial way, they didn't spare the husband's blushes in their evidence. They came along and they gave a truthful account. We say, of course, that this puts the husband's conduct right at the top end, if the top is the worst end, right at the top end of moral turpitude. A sustained and a successful attack on the court's process and on the wife's legal rights. Now, having made those observations, I'm going now, if I may, to go on and consider the legal effects of fraud on judgments.
Before you do,
My lady, yes.
please, Mr. Mitchell, these submissions go directly to the issue that we must determine whether or not Mr. Justice Cohen's decision and order reflected the degree of turpitude that has been demonstrated, as you say, from these matters. My lady, Lady Justice King, thought that there was a compelling reason for this case to be heard in any event, as you've indicated.
Yes.
But is it your submission that this court is going to be able to say there's a scale of turpitude, and if it comes within 9 and 10 at the top of the list, then it must be all bets off, and if it comes between 1 and 2, it doesn't?
I suspect that it would be unhelpful of me to...
Well, is it going to be possible?
No, that's why it would be unhelpful for me to say that. I'm not going to say that. That's why I said at the outset...
Yes, but I'm just asking if you are suggesting at any stage throughout the course of today that this court will be able to issue guidelines as to when it is that a court must say, I can deal with something in de minimis or looking at the matter afresh.
No, I don't think the court needs to go that far. This element of our presentation engages the facts of this case.
Yes.
I will make some general submissions, which I hope will be helpful to this court, about things that they might want to consider, which might set down very clearly the view that a future court might take of non-disclosure.
And we're going to have that at the end, are we?
Yes.
Yes, all right. Just so
Not at all.
Just so I know.
Not at all. So the legal effects of the frauds, these are spelt out most helpfully, I think, in the judgment of the Supreme Court in the recent case of Takar and Gracefield Developments Limited. And perhaps before we turn to that, it's worth me just making an observation there has, in my submission in recent years, been a trend towards the senior courts taking a very robust line against fraud. So we see that in Charland, we see it in Takar, where, in Takar in particular, the court is confronted with the finality principle on one hand and the interest of justice principle on the other, in a quite interesting situation, because in that particular case, what was said was that the victim of the fraud was not entitled to come back to court to relitigate the issue because she could, with due diligence, have discovered the existence of the fraud. That was the reason that was advanced against her being able to bring the matter back to court. And that, in most situations, is a perfectly respectable answer to somebody wanting to come back and say, oh, I've discovered something fresh, could we look at this again, please? The Supreme Court was very robust about that when fraud is engaged, the interests of justice trump the interests of finality, and that has been a trend in a number of cases. So looking now at Takar, which is useful because they talk about the effect of fraud on a judgment, can I invite you please to look at the authorities bundle? And this is the large authorities bundle rather than the small authorities bundle. Is that tabbed? May I refer to tabs in that?
It is.
It is. I'm most grateful. Thank you very much indeed. It's tab 10 then, please. So that is the authority, and there are relevant passages. It's a curious case because two judges give the majority decision, and a number of judges concur in both judges' decisions, but they're not absolutely on all fours. But we don't, fortunately, have to analyse the differences between those judgments in this particular case, because it goes to the ratio of the case, and this does not go to the ratio. So at page 287, first of all, we get Lord Carr. So in fact, I'm sorry, yes, 287. So, quoting, is fraud a thing apart? Does it unravel all? Paragraph 43. In HIH Casualty and General Insurance Limited, Lord Bingham of Cornhill said, fraud is a thing apart. This is not a mere slogan. It also reflects an old legal rule that fraud unravels all. Once fraud is proved, it vitiates judgments, contracts, and all transactions whatsoever. And that's Lord Denning's well-known dicta in Lazarus Estates and Beazley. Later on, he quotes from Lord Wilberforce's speech in Hip Foom Hong and Neoto & Co Limited, which is at the bottom of that page, and the relevant passage, in fact, is over the next page at the top. He's talking about general considerations about the finality of justice. But then he says such considerations do not apply to questions of surprise, and still less to questions of fraud. A judgment that is tainted and affected by fraudulent conduct is tainted throughout, and the whole must fail. And then at paragraph 51, he quotes from a Canadian case, Canada Granitile Incorporated, at the bottom of the page. And the quote is this: all of this is consistent with and in furtherance of the fundamental proposition that fraud unravels everything. We are not...
reference again, please.
So certainly. Page 289, paragraph 51 of the judgment.
Thank you.
Right at the bottom of the page.
Yes.
All of this is consistent with and in furtherance of the fundamental proposition that fraud unravels everything. We are not required to be perpetually on guard so that we are looking to discover the fraud of another party. Where fraud is present, finality will give way to the responsibility of the court to protect its process, so as to ensure that litigants do not profit from their improper conduct. Newey J found the reasoning in the Australian and Canadian cases compelling. I also, said Lord Kerr. And then just turning on a few pages to page 292, please. We're now in the speech of Lord Sumption. The very top of the page. There can therefore be no question of cause of action estoppel, nor can there be any question of issue estoppel, because the basis of the action is that the decision of the issue in the earlier proceedings is vitiated by fraud and cannot bind the parties. If the claimant establishes his right to have the earlier judgment set aside, it will be of no further legal relevance qua judgment. Now, at tab 7 of the authorities bundle, we have the judgment of this court in Charland. And the dissenting judgment of Lord Justice Briggs, whose reasoning was cited with approval in the Supreme Court. At page 209, he repeats the points that I've just made, really. I consider that the now, paragraph 35, I consider that the now undisputed fact that the husband's conduct was fraudulent is a cardinal aspect of this appeal. The general principle that fraud unravels all is, as far as I'm aware, no less applicable to judgments and orders of the court than to contracts. Then just a little further down, it has never been in doubt that once it is established that a judgment or order has been procured by a process involving material fraud, then the interests of justice require that the judgment be set aside. And then, I say with some relief, a paragraph that is actually highlighted already for your ladyship's paragraph 36. It's the middle part, really. There is a public interest in the protection of the court's processes from fraud, which transcends other case management considerations such as finality, economy, and speed. Paragraph 37, I consider that the court should be very slow to depart from that healthy principle. I am aware of no case before this one where such a departure has occurred. And as I say, those words found approval with Lady Hale in the Supreme Court. One further question which might be relevant is the impact of a set-aside order upon property that is passed under it. We describe in our skeleton the earlier payments made by the husband in this case to the wife as being mere payments on account. And the correctness of that presentation is confirmed by this court in the case of Independent Trustee Services and Noble, which is at tab 2 of the authorities bundle. Now, in that case, the wife had secured a consent order which she discovered had been vitiated by fraud, and she applied to set that order aside. And the order was set aside. After it was set aside, it was discovered that the husband had stolen a very large amount of money from a pension fund, and that he was being pursued by the trustees of that pension fund for that sum of money. The wife's financial claim was relitigated and a fresh award was made to her. And the question then arose as to whether she could hold on to the money that she had received, or whether in actual fact the pension trustees were entitled to claim it pursuant to general tracing remedies. And in a judgment which is very difficult for the wife, the Court of Appeal held that in relation to the tranche of money which had come from the pension funds, that when it was paid out under the first order, when she had no idea about the fraud, she was equity's darling and could hold on to the money. But by the time the second order came to be made, she had knowledge of the fraud and thus could no longer claim the status of an innocent party without notice, and she was required to pay the money. Now, that's relevant because what it demonstrates is that when an order is set aside, that the title to the monies that have passed under the order is at risk. And at paragraph 121 of that judgment on page 73, Lord Justice Lloyd confirms his analysis that a sum of money paid out under an order which is subsequently set aside is a mere payment on account. That's the end of paragraph 121.
And what's the point for present purposes?
it goes to a submission that the other side made, that the wife has throughout this period been protected by the orders, and that she's not therefore on risk, if I can put it that way, as against the husband's assets, and that provides a healthy reason, certainly a reason adopted by Sir Jonathan Cohen, why she should not share in the post-separation increase in value. I will demonstrate later on, I hope, why we say that view is not relevant, but it goes specifically to that point. Now, in family cases, the right to set aside is now a statutory right, which derives from Rule 9.9a, capital A, of the Family Procedure Rules. That was added in 2016, following Charland and Gohill, and a number of cases in which the introduction of the new Family Procedure Rules had highlighted a gap in the rules because an analogous provision in the old rules had not been carried forward. That's why, as a matter of interest, when Mrs. Goddard-Watts applied to Mr. Justice Moore, she appealed and didn't apply to set aside, because at that stage the procedure was thought to be that you had to appeal out of time because there wasn't a right to set aside. In Charland, the Supreme Court confirmed that there was in fact a right to set aside, and then the Rules Committee subsequently embodied that right in Rule 9.9a. I'm telling you that because Rule 9.9a includes essentially a statutory codification of the flexibility which Kingdom bestows upon a court as to how it deals with a set-aside application. What Rule 9.9a subsection 5 says, in fact, let me start with subsection 2, so that the court is aware of the scope of Rule 9.9a. A party may apply under this
Is this
rule.
in the authorities bundle?
I'm afraid it's not. I'm so sorry.
That's a shame.
Yes, I know. Shall we arrange for copies to be sent over
I
lunch?
think we should.
Of course. Thank you. Yes, Rule 9.9a, subsection 2. A party may apply under this rule to set aside a financial remedy order where no error of the court is alleged. So that's the point. It's that procedure rather than appeal procedure. Where the court decides to set aside a financial remedy order, it shall give directions for the rehearing of the financial remedy proceedings, or make such other orders as may be appropriate to dispose of the application. So it's clear that there's a discretion, and that Rule 9.9a5 is simply a statutory formulation of the rule in Kingdom, the flexibility in Kingdom which Lord Justice Wilson created. The principle in Kingdom, of course, has been cited with approval by Baroness Hale at paragraph page 230 of the authorities bundle in her Supreme Court judgment in Charland. So it's perhaps worth looking at that because there's no escaping it from our perspective. So it's tab 8, please, of the bundle. Paragraph 43. I won't read the section. I'll make 2 points in relation to it. In fact, perhaps I can give the court just a moment to read it.
Is the essence that it's the enormous flexibility.
Yes, but what I was going to emphasise was earlier on in the paragraph. Baroness Hale says much may remain uncontentious. It may be possible to isolate the issues to which the misrepresentation or non-disclosure relates and deal only with the latter. It's the use of the word may. We say that's relevant, of course, because it wasn't possible.
Well, she's saying one size doesn't fit all.
Yes, that's
and
exactly.
you're saying that in this case, the wife may not receive fair process without a root and branch investigation into what's going on.
Yes, that is exactly our case. But given that this passage has been used by Mr. Goddard-Watts in this case, I did just want to make the following observations about it. In my submission, it's inconceivable when Baroness Hale uttered those words that she intended to abrogate the fair trial rights of a victim of fraud. And similarly, that she intended or probably even anticipated that those words would be used by a fraudster to enable him to escape the consequences of his fraud by retaining the tainted parts of the orders which suit him, or, as we will say, to benefit from their fraud. We submit that had Baroness Hale intended those to be the consequences, she would clearly have said so. And I gain authority for that proposition from other parts of the judgment of Baroness Hale in that case. And I've already taken you to them. So when she says it would be extraordinary if a victim of fraud in a matrimonial case in a worse position than one in an ordinary contract case, she attached significance to the court being able to protect the victim of fraud, and she cited Lord Justice Briggs with approval when he talked about the public interest in the protection of the court's processes from fraud, which transcends other case management considerations such as finality, economy, and speed. And in my submission, her reference to case management must be seen in that context. While I'm being refreshed, can I invite the court, please, now, thank you very much indeed, to turn to tab 4 of the authorities bundle, which is the case of Kingdom. Now, the relevant part of the passage is at page 1, but part of the judgment is at page 102, when the judge is considering the second point in the appeal that he was determining. And in that section of his discussion, over the page on page 103, he sets out the general principles which have given rise to this flexible approach that is used in the family division. But the judgment, particularly in this context, has, in my submission, to be seen in light of its own facts, because it's easy to read the beautifully expressed clear principles that Lord Justice Wilson characteristically sets out there and overlook what he was dealing with. So in that case, the husband had given dishonest disclosure. Not once, but twice. And Lord Justice Wilson comments on how unusual it is for there to have been what he describes at paragraph 21 of his judgment, compound dishonesty. The wife applied to set aside, and the judge dealt very robustly indeed with the application. He set aside the order and immediately supplemented the previous order with an additional lump sum, which he intended should compensate the wife for the sum of money which the husband had failed to disclose at the time. The husband said, "Oh, no, you've got to be consistent about this. You're setting aside, I'm entitled to a full rearing, and that's important for me because my financial circumstances have got worse." So he, the fraudster, was contending for a rehearing so that he could argue that he might be able to claw back some of the money he'd previously paid to the wife. And it is against that background that Lord Justice Wilson was considering the application to appeal. Now, at that time, in the family division, I don't think that non-disclosure of the sort that we're dealing with in this case was so routinely described as fraud. That epithet has its origin in the judgment of Lord Justice Briggs, in fact, in Charland, who labelled the disclosure in that case as fraud and basically invited us to use that epithet so that we had in mind the principles where fraud is engaged. But at this time, non-disclosure was how it was described. But the judge was very clear that there was a discretion that the court had, but that the discretion had to consider all the circumstances. And he cites a passage of this court in the case of Williams and Lindley at the top of page 103, where Lord Justice Thorpe is considering the principles to be applied when an order is set aside because a new supervening event has occurred, which in the interest of justice the court should consider. And he talks about a valuable distinction. He says, I would emphasise that this case is to be clearly categorised as a supervening event case and not a case of a tainted order. Accordingly, nothing that follows is to be understood to apply to taint cases where the procedure and adjudication may need to reflect the degree of turpitude of the party responsible for the taint.
Sorry, page, paragraph.
It's paragraph 35 of the judgment, my lady, page 103, and it's the quote.
Of course, yes.
Do you then need to go on to what is contained in 36, 37 and 38?
Oh yes, absolutely. But nothing. So Lord Justice Wilson then at 38 summarises what he thinks are the relevant principles, and we don't demur from those at all. He had a discretion as how best to proceed. In the exercise of discretion, he was required to seek to deal with the case justly and thus in a way which was proportionate to the complexity of the issues. Non-disclosure was of a discrete element of the husband's assets and it generated a defect which could be cured by one simple enlargement. Order had been fully implemented. The husband's lies in the proceedings, compounded by his further lies in the correspondence which preceded issue of the present proceedings, yielded a conclusion that were there to be a second updated inquiry into all the matters specified in the subsection, no assertion on his part in relation to his financial circumstances, for example, of any current inability to pay to the wife what would otherwise have been her appropriate share of the gain on the shares, would be likely to be accepted unless clearly established following protracted and costly examination. In the words of Thorpe, L.J. and Williams and Lindley, the procedure needed to reflect the degree of the husband's turpitude. So in actual fact, it was the husband who was deprived of what he was contending were his fair trial rights at that time. And whilst it was a logical argument for him to run, it seems to us on this side of the case that had the language of fraud then been adopted, Lord Justice Wilson could easily and possibly even had in mind the idea that had the husband been able to secure a re-evaluation of his rights and a repayment of assets that had previously been paid to the wife, he would have been benefiting from his fraud, and it would have been wrong to allow him to do so.
Thank you.
My lady.
I just want to be clear about this, Mr. Mitchell.
Yes.
I don't know that any of these principles, which you are so comprehensively articulating with great skill, are an issue, and I'm pretty sure that they're not. But we've got to see how they apply to the judgment of Mr. Justice Cohen, and I'm sure you'll be coming to that in due course. But one of the issues that you're asking us to look at is the context of the cases in which these principles derive.
Yes.
And of course, the principles so far are in relation to cases in which there is a clear demarcation line as to when the deception occurred and what was left out of account. And we're in a situation where it seems to me that you're saying that the degree of turpitude, which you ask us to find, is at the highest, and we may do so, I don't know, but is such that it prevents the clock stopping as at 2010 and it carries on to 2021. Is that correct?
Yes. Yes.
So that's it?
Yes.
So the difference in all of the cases that have gone before is that they have never been asked to consider carrying forward effectively what was determined to be a marital request beyond the time when it would normally crystallise.
Yes.
So that's the difference.
Yes, that is one of the differences. And for what it's worth, we say that the the fraud is relevant to both the procedure and the adjudication, not because we say so, but because Lord Justice Thorpe says so in the passage of Williams and Lindy, to which I took the court a moment ago.
That's procedure.
Well, he says procedure and adjudication.
Right.
Both those words are in italics.
Did Lord Justice Thorpe, in Williams and Linley, suggest that the fraud, because we shouldn't be shy about calling it that, the fraud was sufficient to effectively undermine all other principles normally applied in financial settlements between divorced couples in relation to marital bequests and their identification?
The answer to that question is no, he didn't, because Williams and Linley was not a fraud case. Williams and Linley was a supervening event case. So something completely unforeseen had happened. The court was persuaded it should revisit its earlier order. So he didn't have to grapple with that issue.
That was something that had reference to a marital bequest.
Yes.
Yes.
And that's why when I opened this appeal, I was anxious that the court should understand that essentially it's a clean sheet for this court. There are no authorities that set out precisely
Yes, but I just want to know exactly where you're coming from.
Yes.
In parochial terms, and that's it, is it?
Yes. Well, it will be my submission that when the court comes to consider this matter genuinely de novo and with a clean sheet, which we say has not happened before, it is inevitable when you have a significant period between separation and consideration of the financial picture that there will be arguments about what I'm going to call post-separation accrual. The husband will say, I'm responsible for the increase in value, and I'm responsible for it at a time when the wife has ceased to make her contribution to this family. The court has a discretion about how it deals with that argument. The authorities are quite clear, there's no right or wrong answer. And I will say, we will submit, that one of the factors that goes to that discretion is the reason for the delay.
I see.
And since we're dealing with that now, let me make the submission.
Well, I don't want to take you off course, but I do want to know exactly what your case is, and it's been clarified.
I'm most grateful, thank you. You will probably be relieved to know that I am now going to turn on to how Sir Jonathan Cohen dealt with this.
Yes. Case. I'm going to give you this indication, if I may.
Yes, of course.
It's necessary for us to have a short break.
Is now a good moment?
Well, it might be. I was going to say about 11:30, so that we split the morning up, because we need to have some mobility at some
understand.
stage.
Of course.
But when would it be appropriate in your scheme of things to do that?
Well, now probably is a good moment, if it's not too early for your ladyships.
Is that okay? Yes.
Thank you. I'll come back. I'm just back in a second. I'm just going outside for just a moment, if I may.
She said 11:30.
But now she wants to say she wants 20 minutes.
Oh, right. 20 minutes.
Mr. Mitchell, we'll be able to go on now until 1 o'clock.
Thank you.
We may need to take a break in the afternoon for the same reason. It's just to get mobility, you understand?
I couldn't be more sympathetic, my lady. We've got the relevant section from the family proceedings, if I could hand that up.
Yes, please.
Tim, do you need a copy, or are you all right? I'm all right. Okay, thank you very much. I think there's some more copies than we need. There we are, 3 copies. Thank you.
And we're now going to go to the judgment of Mr. Justice Cohen.
Yes, please, yes. Which begins, I think I can't refer to tab numbers, page 45, please, of the main appeal bundle.
Thank you so much. Thank you.
Oh, is it? Yes. Sometimes, when one reads a judgment, one has to read a vast section of narrative before one gets to the rationale, or in order to discern the rationale. Sir Jonathan Cohen is the most wonderfully clear judge, and his rationale is contained in a very short passage on pages 57 and 58 of the core bundle, paragraphs 78 and 79. So he sets out, prior to that, the relevant background, and then dives in and sets out why he is going to take the Kingdon approach, as he puts it. And by the end of paragraph 79, he's set out his rationale, really. And so we need only to look at those 2 paragraphs in my submission. I intend now to focus on them.
Thank you.
I've already said that at paragraph 78, surprisingly, we say, in light of what Sir Jonathan then goes on to do, we have an acknowledgement by him that up to that point, the wife had been deprived of her opportunity of being able to consider the resolution of her claims with full knowledge of what the asset base was. And I've already reminded the court of the central importance of that knowledge in any financial case. We say, of course, that paragraph, the facts he relates in that paragraph, should have set alarm bells ringing in his mind. He should have had in mind at that stage that he was required to consider the fair trial rights of the wife and the moral turpitude of the husband. But there is no consideration of either of those issues, or of whether or not the husband was benefiting from his fraud by the approach that he proposed to take. And actually, in my submission, those failures alone are sufficient to justify this appeal being allowed. But they are not, I'm afraid, the only failures on the part of Sir Jonathan. So he goes on then and provides the 7 reasons for applying Kingdon in this case.
Before we go there,
Milady, yes.
I just want to be very clear what you're saying the 3 immediate deficits were. So he failed to consider the impact upon the wife.
Yes, fair trial.
He'd failed to consider the impact upon the integrity of the court.
Yes.
And that...
Well, in actual fact, the impact on the wife and integrity of the court are the same point. So the losses to the victim are point...
Are they?
For the purposes of my submission, they were. I'm happy to break them down into 2 points. But yes, it seems to me that there was a failure to consider who had suffered, who was the victim, and what their rights were. And in this case, the victims were Mrs. Goddard-Watts and the court.
Well, I don't think the court was a victim, but the court's got an interest in the integrity of its procedure, which is why when people are sentenced for breach of injunctions, that part of the sentence, part of the penalty, incorporates the fact that the integrity of the court has been undermined.
Lord Justice Briggs refers to it as an injury to the court's process, and that's what's so.
Yes,
there was,
it's not a victim. it's subject to the injury,
Yes.
Which it can obviously
Yes.
repel
Yes.
or
Yes.
accommodate by penalty. So it's the wife as victim of the fraud,
Yes.
the court's integrity,
Yes.
or the process of the court's
Yes.
integrity,
Consideration of the husband's moral turpitude. And I'm sorry, because of that analysis, we're now on the fourth one. Consideration of whether the husband benefited from his fraud. So whether by taking the approach that he proposed to adopt, the husband was benefiting from his fraud. And since the maxim that a person should not benefit from their fraud is, in my submission, an overriding rule of public policy, plainly that should have featured in Sir Jonathan's consideration.
Is it fair to say he didn't consider moral turpitude? I mean, if you read paragraphs 78 and 79 together, he does say he bears those points strongly in mind, and those points are the criticisms of the courts in the past.
Well, he does, but he certainly doesn't seem, in our submission, to evaluate that turpitude or decide where on the scale it is or how it fits into the discretion that he is exercising.
so it's a valuation.
Yes. I mean, this is perhaps a harsh thing to say, but in the context of this case, where it seems to us the moral turpitude is of the very highest order, it is possible to say that Sir Jonathan was prepared to overlook it, because he was nonetheless prepared to allow this husband to secure a judgment based upon the narrow Kingdon approach.
Is that the only reason you say that?
Is it the only reason that I say that he overlooked it?
Yes. Are you saying that because he adopted the Kingdon approach, it must inevitably mean that he failed to carry out a correct evaluation of the moral turpitude? Or is there some other factor?
No. I say he failed to carry out evaluation. Certainly, as I read this judgment, there is no evaluation of moral turpitude in it, but I, of course, entirely accept my lady's point that he at least recites in the most summary form and without, in my submission, any moral evaluation, the facts that had led him to be dealing with this case 12 years after the wife had first issued her Form A.
So of the 4 failures,
Yes,
which we've now identified,
yes,
the injury to the court process can be taken as read.
Yes.
That the wife has been a victim of fraud can be taken as read
Yes.
on the findings. There's the evaluation of the moral turpitude that we must consider, and the benefit to he who has perpetrated the fraud.
Yes.
And that's what you're going to
I will
do from the judgment.
I will do. Yes, and it's plainly missing from the judgment because there's no consideration of it at all. So Sir Jonathan does not apply his mind to that question at all. I am going to seek to demonstrate to this court that the husband has benefited from his fraud.
Yes. Okay.
Yes, one further question
Milady,
on
yes.
that. When you talk about benefit from the fraud, are you talking about financial benefit or wider benefit? What precisely do you mean?
Financial benefit. We say the husband has placed himself in a very much better financial position by being able to place reliance upon tainted agreements and orders that he induced the wife to enter into earlier on, or the court to order earlier on, than would have been the case had those orders not been made.
And you may expand on this, but I mean, to what extent is it appropriate to go into the detail of any such evaluation? Is it enough for the judge, when you say carrying out the correct thought process, to say may benefit from the fraud? It may be difficult to take a view on what the true financial outcome would be. Is it sufficient? Does the judge have to take a positive view on likely financial benefit or disadvantage from the fraud, or is it enough to say the husband may potentially benefit?
It seems to me that the answer to that question depends upon the exercise that the judge is at that moment in time conducting. So if the judge is asking him or herself whether or not they should adopt the Kingdon approach or a wider approach, then plainly a relatively broad evaluation of the position with the fraud, the position without the fraud is possible, and that can be relatively quickly dealt with. If the court is quantifying a financial award, and has to have regard to the principle that a fraudster should not benefit from their fraud, it must follow that a more detailed evaluation needs to take place. But actually, we would submit that is not something that it will be difficult for an experienced family judge to do, to ask themselves what position they would have adopted. In this case, Sir Jonathan should have asked himself what the outcome would have been likely to be in 2022 if this was a first-time application.
And so what you're not doing at any stage is suggesting that but for the fraud, the wife would have had the opportunity to come back to the court. It's the fraud, purely and simply, that makes this a very unusual situation for the court, which has to then reassess the usual boundaries.
Yes.
So in the case, and it goes to what my Lady Justice Carr has just asked you.
Yes.
We see that the judge, prior to the rationale that he adopts, as you say, refers to the facts that had led the case to be before him.
Yes.
Now, you've said, with the greatest respect to Mr. Justice Cohen, that it's in the, quote, most summary form, end quotes.
Yes.
Now, does he need to articulate the exercise of evaluation in terms of, I put this into the balance of the turpitude question? In the cases that you've referred us to, Kingland itself and Lord Justice Thorpe, they were taught, well, not Lord Justice Thorpe, but Lord Justice Wilson, as he then was talking about compound deceit.
Yes.
Is that sufficient? If Mr. Justice Cohen had said, I am dealing here with a man who has not once but twice, in significant fashion, misled not only his wife's advisors but also this court, would that have been sufficient? Or does it need to be more?
What it needs, in my submission, to do is to demonstrate, in this case, to Mrs. Goddard-Watts, the losing party in this argument, why she's lost the argument. So she submitted all of these points to Sir Jonathan Cohen and explained why they were relevant, and we do not see in his judgment an enunciation of why he dismissed
That's in this case. So it's demonstrating to the victim of the fraud or to the fraudster why the judge has evaluated that degree of moral turpitude that he or she determines to be applicable in the case.
Yes.
That's what you're saying. Okay. So going back to the facts of this case, and I'm sorry I interrupted you.
Not at all.
You're saying that what we see before those paragraphs where the rationale is set out in 78 and 79, Mr. Justice Cohen unfortunately did not do enough, even though he seems to have adopted the degree of surprise and censure of the judgments, particularly of Mr. Justice Holman.
Yes.
All right.
Yeah. So moving now, if I may, on to the 7 numbered paragraphs on page 58. We have, I'm afraid, criticisms of each of them. So the first can be very shortly dealt with. It is not right to say that it was a single issue case that was about the value and realisation of the husband's shares in CBA. It was about the points which I have made to this court this morning. And I'm not going to invite your ladyships to read the document now, but in the supplementary bundle at page 113, you will find the skeleton argument of the wife.
213?
No, 113, please. So that's the beginning of the skeleton argument. You can see that it's a lengthy document, but you have only to see from the second paragraph, fraud unravels all, and what follows, that it was not about, or solely about, the value of this company. It was about the approach the court should take to my client's fair trial rights. So that paragraph in my submission just does not bear scrutiny. Then he says, the wife received her fair share of the non-disclosed trusts in 2016 and her share of the other assets in 2010.
Sorry, it's going back to your first point.
Milady.
Putting the fraud aside, was it a single issue case? For putting that side of it, was it a single issue case?
Well, inevitably, any issue of matrimonial proceedings leads to the overriding issue, which is how the assets should be divided. So I suppose I'd say the factual issue was the value of the business. There was then, of course, the issue about how it should be divided between the parties. But the point I'm making there is that it isn't accurate to characterise this case simply as being about the value of the shares the value and realisation of the shares in CBA. So point two, and we make a number of points about that. Our overriding submission is that the court was simply not in a position to characterise the previous distributions as having been fair. Now, I've already taken the court to the relevant passages in Carr which talk about the treatment of a judgment vitiated by fraud. And we say, as a matter of policy in the circumstances of this case, Sir Jonathan Cohen ought not to have placed any weight upon the earlier agreement or the earlier judgment. And certainly, he should not have built a case that the distributions affected by those tainted transactions were fair, when in actual fact, the whole edifice was built upon fraud. Now, there's some reliance by the husband on a case which is, I think, at tab 2 of the authorities bundle. There's no need to look at it at this juncture, called H&H. Let me just make sure I've told you that it's in the right place. Oh, I'm sorry, I'm most grateful. Tab 1. Thanks, Jim, very much. That is a case in which our husband, an accountant, embarked on a business venture as his marriage broke down. And he didn't wait for the court to adjudicate upon his claims. He said, this is what we're worth, and I'd like to give you half of that now in cash. And he did that. And the question then arose, when the financial claims came on some time later, whether that was a fair thing for him to have done, whether the result was fair. And Sir James Mumby, who was the judge in the case, said, yes, that was a fair thing to do. The wife's claims, subject to an adjustment that he made in actual fact, were fairly dealt with at that stage. That, as I understand my learned friend's argument, translates into a submission that it's appropriate to perform that exercise here. To say, well, objectively speaking, was it fair what the wife got in 2010? And if it was, then the court ought not to interfere. But in our submission,
Did Sir Jonathan refer to H&H?
No, I don't think. I don't think. Oh, I'm so sorry. I'm told that he does. Thanks. Mr. Webster is just going to confirm that position. He can do it speedily on his iPad.
Yes, sorry. Thank you.
So that is, if a fair division made, no need to return.
Yes, that's the submission which is repeated in this court by my learned friends. But of course, the difference between H&H and this case is that the husband at all times in H&H was acting with honesty and integrity. In our submission, very different considerations pertain when a person obtains a distribution of assets through fraud. So
That's almost, you're almost saying, well, if there's fraud, then nothing else really matters.
Yeah, well, yes.
And is that consistent with your submission that there are one of the things that a judge needs to consider at the outset is likely benefit from the fraud?
Well, that submission is based upon the pragmatic approach that the court takes. I'm not going to succeed, it seems to me, if I submit to this court that in every case fraud unravels all.
Well, that wouldn't be consistent with the approach set out by Wilson, would it?
That's exactly why I'm not going to succeed, and I'm not going to waste this court's time by pretending that I could make that submission, because I can't. So in every case, there is an evaluation to be undertaken, and it's plain in my submission from the authorities that the existence of fraud will be a very serious thing for the court to measure in those circumstances.
Okay, let's get this straight.
Yes.
Are you suggesting, Mr. Mitchell, that effectively, if we get a very high degree of moral turpitude, the fraud is significant, is material, that the court, regardless of the normal principles, even taking into account what you're asking us to do, must nevertheless, even if it finds that there's been a fair division or a sufficiently fair division, must penalise the fraudster? Are you saying that?
I'm saying that if fraud is present and the fraudster has benefited from that fraud, then the public policy would suggest that they should not be able to. And if that results in the court making an order which it would not have made but for the fraud, that is a perfectly satisfactory thing for it to do.
I've put it very clumsily, I'm sorry. Just suppose that we were with you on your submissions, and we come to the conclusion that, first of all, that there was a very high degree of turpitude that is not reflected in the order of Sir Jonathan Cohen. That we take into account your submissions that he went astray because he had failed to bear in mind, particularly an appropriate evaluation of turpitude, and that the husband benefited. So suppose Sir Jonathan had gone back on all the figures, crawled over all the figures again, decided, as you ask this court to do, that the delay in finalising this once and for all, well, one hopes once and for all, is by reason of the husband's fraud, but nevertheless there's been a fair division in the past, because whatever happens between then and now, are you saying that nevertheless the court should penalise the fraudster by going outside the normal sharing principles?
I don't think that I would put it in that way, because I think that it is inherently unattractive for family court to consider that it's penalising anybody. I mean, even when family judges are confronted with cases of barefaced contempt, they don't like to talk about punishment, do they? They like to talk about.
Well, that's a matter for the Attorney General and contempt of court.
That's right. So I certainly don't seek to introduce that language into the law of ancillary relief.
Well, I know you don't, but I want to be straight about it.
Yeah, no,
if you're saying, and it comes from H&H, if you're saying that the court, bearing in mind all that you're saying now, once it examines the process, comes to the conclusion, whether you agree with it or not, that there's been a fair division, taking into account all of the necessary factors, you're not saying, and I'm inviting you to say whether this is correct or not, you're not saying that the court should say, well, usually, taking an example, it would have been 50-50, but because of the husband's fraud, we're now going to make it 60-40.
Well, the court, of course, is able to consider conduct. May I just have a moment?
Yes.
Maybe the answer is written on this. Yes. Thank you very much. Thank you. What I was going to say was the court does have the statutory power to consider conduct.
Yes.
So that's the first point.
Yes.
So the court may consider that where a division of assets has been frustrated, a fair division of assets has been frustrated over a prolonged period of time, such as has happened in this case, that it is relevant conduct to factor that in and thus make an award that would be different to the award that it would have made had
And that's in accordance with all of your submissions so far. I understand that submission.
Yes.
But you've actually said where a fair division of assets has not taken place. So if the court concluded that although it's come about in a very wayward fashion, that actually the division was fair, do you go beyond that and say that there should be well, I think your answer is that the court should put into the balance the conduct which is fraudulent, and that needs to be given appropriate weight
Yes.
in such cases.
Yes.
That's what you're saying, not a penalty, but that in accordance with the statutory test, section 25,
yes.
conduct
Yes.
can be a tipping point.
Well, can I illustrate it in this way on the facts of this case? It would have been perfectly possible for the husband to secure for himself the entire post-separation gain in the value of his business by the simple expedient of giving disclosure that was full, frank and clear, and thus locking the wife into the division that was made in 2010. By not doing that, the court is driven to consider the facts now, and of course there's scope, isn't there, for an argument about post-separation accrual and contribution. We say that one of the factors that should bear on that argument is the reason why the court is looking at the matter 12 years on.
Which is conduct.
Yes.
So it's already there, you say,
Yes.
and nobody's been taking
Yes.
it up.
Yes. I've just made submissions about H&H and about the policy that we say ought to prevent the husband from being able to place weight, or the court for that matter, on being able to place weight upon judgments and agreements that are tainted by fraud in the way that these ones are. But I'm going to now to stray beyond the realm of the theoretical, though I very much hope that this court will endorse the submissions that I've made in relation to it, and look at the facts of this case. So Sir Jonathan Cohen finds that the wife received her fair share of the non-disclosed trust in 2016 and the share of the other assets in 2010. But in my submission, he was not in a position to make that finding because he had to have based it upon the valuation of the business that was provided to the wife in 2010, and which we now know was tainted by the lack of good faith of the accountant, who was presenting himself as an honest broker, but was in actual fact not an honest broker. He was the husband's stooge, I was going to say. It's not a very attractive word for this court, but he was acting in the interests of the husband when he was representing to the wife that he was an honest broker. So we have that.
But you said before he was acting under his influence.
Yes, yes.
Whichever way it comes
Yes.
to, he was
Yes.
not believed by
No.
the court.
No. And the court made the point that he was representing himself as being an honest broker, and he wasn't. We then have the tainted value in 2016 of the husband's business interests, both at 2010 and at 2016. Now, I've already demonstrated that David Green was misled. He had dismissed as irrelevant a valuation which in actual fact was not only highly relevant, but which came to pass.
But did that go to the Mr. Green's 2010 valuation?
Well, the answer to that question, Milady, is that it's impossible with clarity to say. So what David Green did in that exercise was take the purist accountant's approach, as he was bound to do. So he asked himself, what would an accountant have valued this business at if they were valuing it at 2010? Now, that approach prevents an accountant from looking at future events. And there's nothing to criticise Mr. Green for doing that for, but there are plenty of authorities in the family court in which that approach is deprecated as being unrealistic. So consider this. David Green provides his valuation of this business the day before the offer is made for 100 million, the valuation is 100 million pounds. He would quite legitimately say that on the day before, that valuation, my valuation of 25 million pounds, is absolutely accurate. I cannot look forward and predict that an offer is going to come in for 100 million pounds. So as an exercise in accountant's orthodoxy, it's unimpeachable. But judges sitting where you do routinely look at events that take place beyond the purview of an accountant's valuation and use that to affect the value that they ascribe to an asset. So in this case, a second limb to our attack is that although we don't know what David Green would have said about the 2010 valuation had he known the truth about the sale in 2016, perhaps more importantly, we don't know what Sir Andrew Moylan would have said if he'd received submissions from my client based upon that evidence.
Yes, so Mr. Justice Moylan, as he then was,
Yes.
in 2016, when he accepted the fair division in 2010, was also not apprised of the full true
Yes.
facts.
Yes.
So you say that the, as it were, the reliance by Sir Jonathan on that approach is
Yes.
undermined
Yes.
because the approach then may have been different.
Yes. Which undermines the matter of law because I've already demonstrated from Takar what the status that a set-aside judgment has, which undermines as a matter of fact. So the conclusion just was not safe. Sir Jonathan Cohen could not, in my submission, say that my client had received a fair share of the assets because there's so much doubt about the value of the assets that passed under that order. Now, the third reason is consistency with Mr. Justice Moylan, but that doesn't provide the justification in my submission that Sir Jonathan seeks, because, of course, we now know that Mr. Justice Moylan was himself being misled when he gave his judgment. And we cannot know what Mr. Justice Moylan would have done had he known the truth. There are a number of justifications contained within the fourth reason. The first is that there was no attack on the valuation of CBA in the hearing before him in 2010. That simply is not factually correct, and we can look at it now.
Was it 2010 or 2016?
I'm so sorry, it was 2016. It was 2016.
Right.
I said 2010, it was 2016. One has only to look at the wife's skeleton argument for that hearing to see that that was simply not true. So in the supplementary bundle, the wife's skeleton argument can be found at page 124, or the relevant passage in the wife's skeleton argument is found at page 124.
So paragraph 22.
Yes.
So this, in fact, was a skeleton argument in order. It wasn't before Mr. Justice Moylan, as it then was. No. This was the skeleton argument in front of
Sir Jonathan. Sir Jonathan Cohen.
And what you were doing...
Was it, or was it to set aside? Is this the skeleton argument before?
No, this is the wife's skeleton. So it begins at page 113. Yes. This is the wife's skeleton argument for the final hearing in front of Sir Jonathan Cohen on the 24th of January 2022.
Right. And we don't have the skeleton argument that was put before Cohen J.
I don't think we do.
No, but this is presumably repeating quite a lot of it.
Yes, and this is the wife's case in front of Sir Jonathan, and it's relevant because, as you can see from paragraph 22, Sir Jonathan is incorrect to record that there was no attack made by the wife on the value.
I'm not sure he is incorrect. He's talking about attack on the disclosure in 2010. At which point there was no offer to disclose. Depends how you read it.
Yes, I can see what your ladyship says. There's never been any attack in this hearing against the husband's disclosure of the value.
Disclosure in 2010
yes,
of the value
yes.
of CBA.
I don't intend to airbrush out the words disclosure of, but I think we're arguing about the same thing. So the point was the wife based her judgment about the deal that she did in 2010 upon the husband's valuation that he presented at that time of his business assets. And what has been said against my client ever since is, well, that was a fair distribution. You thought the business assets were worth £6 million and you took a specific sum of money to buy you out of your interest in those assets, essentially is what's being said, and that nothing that has emerged subsequently has demonstrated that that is unfair. That's the case that's taken against us. My submission is that we can now say, for two reasons, the reason that Mr. O'Donnell, the author of the valuation, is undermined, and now the only independent value, Mr. Green, is also undermined, that in actual fact there's no evidential foundation for that assertion upon which the husband can rely. So in other words, Sir Jonathan Cohen could not be satisfied that the value in 2010 was a reliable one, and therefore that the wife received her fair share of that value at that time.
And
Milady.
is the position this, in respect to this skeleton argument, perhaps captured in paragraph 15, that this is a single continuum, and it's a continuum of what you say is a fraud, which
Yes.
undermined the basis of what was an order made in 2010,
Yes.
albeit a different nature of a fraud in 2016,
Yes.
but again, the continuum.
Yes. Yes. Which have emasculated, we say, my client's fair trial rights, which have not yet been restored.
So looking at paragraph 22
Yes.
of the skeleton argument before Sir Jonathan, it's framed, as it were, as a response to a prospective argument that it's anticipated that the husband will make,
Yes.
rather than the wife's case. So H will undoubtedly argue that Moylan J did not disturb the remainder of the order made on 1st June 2010 on the basis, he said, that that was a largely fair division. But as the court now knows, Moylan J's judgment as to the current assets was based on the false disclosure which H and ROD had made about the value of his company, the truth of which, had it been known, would have altered the entire financial landscape before the judge. So you put it fairly and squarely before Sir Jonathan,
Yes.
that you can't say we can now take point A
Yes.
as being 2016.
Yes. Yes.
That's your point.
Yes.
All right.
And 23 is relevant to this.
Right, okay. So when Sir Jonathan says there's never been any attack in this hearing against H's disclosure of the value of CBA in 2010, that's correct, but that's not the end of the story. No. Because as you say, then we've got all of the other
Yes. Yes.
turpitude,
Yes.
benefits,
Yes.
and all the rest.
Yes.
Okay. And this is what you say demonstrates the failure of Sir Jonathan to get to grips with the four issues that he must
Yes. Yes.
he must take into
Yes.
account.
Yes. I just have a memory. Yeah. So that's the first sentence of that, and then weight is placed by Sir Jonathan Cohen upon the independent valuation that he had available to him of Mr. Green as to the 2010 value of the company, which Sir Jonathan Cohen, rightly in my submission, characterises as having been in the right region. But of course, as I've already said, that valuation is also tainted. And then Sir Jonathan places weight upon all of those factors because in his final sentence, little paragraph 4, he says it was part of the basis of the parties' agreement. But with respect to him, we would say that no weight can be placed upon an agreement that is undermined, or any element of an agreement that is undermined by fraud. What Sir Jonathan is doing is allowing the husband to cherry pick and retain the advantages of those parts of the agreement which now suit him. and that is not something which he should be permitted to do. Now, reason 5 is, in my submission, essentially the same as reason 2. My client's already received her fair share. He goes on and makes the point about contribution, and that's relevant to our separate ground of appeal. Paragraph 6 in my submission contains, it's irrelevant to the exercise because it overlooks that my client is a victim of fraud and the husband is the fraudster. It isn't right to say that my client has not had to bear any of the risk in the value of the value of the company, or that the wife has received her fair share for reasons I've already explained. The parties are simply not in an analogous position because my client was essentially locked out of receiving her fair share by the husband's fraud. The husband could easily have preserved his share by simply telling the truth. But in absence of that, what has happened to this asset is, in my submission, irrelevant. Whether its value's gone up or down is irrelevant to the question of whether my client has received her fair trial rights and a fair share of it. And it's no answer to that to say, oh, well, the wife wasn't on risk at all material times. In any event, of course, as we see from the salutary tale in Independent Trustees, a wife setting aside an order because she seeks to assert her fair trial rights does find herself back on risk.
Sorry, did you refer us again to Takar?
No, independent trustees and nobles and noble. That was the case where the wife set aside and then.
It's the pension fund.
Yes, that's right. That's right.
Is that Morris and Morris?
Yes, it is. Yes. Now, there's another point to be made at this stage about sharing. The husband is very keen on using that word, and it's adopted by Sir Jonathan in his judgment. But in our submission, in this context, sharing does not have the meaning that ordinary people might ascribe to it. So, of course, we accept that the wife had a share of the assets in 2010. The money that the husband paid the wife was a share in their assets. But in this context, in our submission, sharing must mean sharing in the technical legal sense. That is to say, an evaluation by the court of the wife's entitlement pursuant to the sharing principle enunciated by the House of Lords in Miller and Macfarlane. And that requires due process in the course of which the court considers all of the relevant facts, as it's bound to do under the statute, and then adjudicates upon the claim. That process has been woefully lacking in this case, so far as my client's claims are concerned. But it isn't in my submission apt in those circumstances for Sir Jonathan to say that the wife had received a fair share. Reason 7, finally, is, in my submission, completely irrelevant. This is not a case where a person has received a share of the assets in an untainted order, discovers that the value of the assets retained by the other party have gone up, and scurries back to court and says, I want more. Those are the principles in Cornick and Myers. Well, in actual fact, in one of those cases, the value of the assets has gone down, and the person who retained the less valuable assets came back and said, I want the court to look at this again. Now, for perfectly acceptable public policy reasons, in those circumstances, the finality principle trumps everything, and the court won't look again. But this is not a case in which the husband can pray and aid the finality principle. So there's no question of my learned friend securing assistance for his case on reliance upon Cornick and Meyerson, both of which are concerned with completely different scenarios. So for those reasons, we say that the justifications advanced by Sir Jonathan Cohen and that paragraph of his judgment do not withstand scrutiny. Now I'm going to deal with the remaining points as quickly as I can, because I'm aware that time is marching on and I certainly don't want to deprive other people in this court of their opportunity to address the court. I said that I demonstrate, or endeavour to demonstrate, how the husband has benefited from his fraud in this case, and I can deal with that very shortly. In my submission, the correct analysis is for the court to ask itself what the position would have been in 2022 if Mrs. Goddard-Watts presented her Form A for the first time then. And that happens all the time. People separate and they reach amicable arrangements, and then for one reason or another, somebody wants to formalise to come to the court, often many years after formal separation has taken place. So it's not a novel situation at all. It is encountered. This was a long marriage. And the business asset was established during the marriage. It would be treated by a court as matrimonial property. The assets are valued as at the date of trial. Now, with assets of £79 million, the case would be resolved pursuant to the sharing principle, not pursuant to the needs principle.
So just remind me where you get the 79 million from?
£79 million are the assets that were in front of Sir Jonathan Cohen at that time.
Thank you.
And the general principle is that a person on divorce takes the highest of the sum that they'll be awarded pursuant to the needs principle or the sharing principle. And in every case, the court has to ask itself whether needs are met. But when you've got tens of millions of pounds, the court won't spend very much time on that, because obviously needs will be met if you have a sizable share of that. So this isn't a case in which the court will be saying, well, what does this person need? They would be looking at the sharing principle. Now, another commonly encountered argument is when the value of an asset has gone up after divorce, and the person who holds that asset wishes to contend that they should have an unequal share to represent the value of the post-separation increase. A perfectly common argument, and unhelpfully from the point of view of a practitioner trying to advise, there's no clear answer as to how the court will approach that. It's a discretionary exercise. There are at least three ways of a court considering it. It can take a precise arithmetical approach. What was the value at the date of separation? What's the value now? We'll divide the matrimonial and leave the non-matrimonial untouched. There's a straight line approach. What was the value when the value was naught when the business was started, and now it's £100 million, and the marriage lasted for 5 of the 10 years. Half of it's matrimonial, half of it's non-matrimonial. That's what's called the Martin and Martin approach. And then there's what's called the fair overall allowance approach, which some commentators have rather unkindly called the finger in the air approach. I wouldn't be that unkind, but it's a discretionary approach that requires which requires an experienced judge to stand back and ask whether the result that they propose is a fair result, having regard to all of the facts. Now, the arguments are not all on the husband's side in cases like that, because the counter-arguments that a wife has are that the husband is trading with her undivided share. So in other words, what's gone up in value is something in which the wife had an interest, and that interest has increased in value at the same time. That's a perfectly valid argument for a wife to run and would feature in this case. And so would the argument that the post-separation increase in value is partly the product of latent value that was built up during the marriage and is projected forward and just realised after the marriage, but nonetheless is matrimonial in nature. Those are the debates that will be had in this case. And they're all perfectly respectable debates, and I wouldn't criticise anybody for running them in this case. But when that debate has been had, the court is required to stand back and assess its overall result against the yardstick of equality, making sure that there's no discrimination between the domestic party and the moneymaker, and asking themselves whether the overall proposed percentage division is fair in the circumstances. And in my submission, it is inconceivable that after a marriage of this duration, producing children and to which my client continued to make a contribution after separation, because if you recall from the judgment of Sir Jonathan Cohen, he specifically comments that it was not anticipated at the time of separation that the wife would have to bear the sole responsibility for bringing up the children after separation, but she did bear that responsibility. That would sound in a percentage division, and in my submission, that percentage division simply would not be 9% to the wife and 91% to the husband. And by that relatively simple, and I apologise, it was a bit laborious, but that relatively simple process, a judge can easily have demonstrated to themselves that what the husband was proposing enabled him to benefit from his fraud, because he alone was responsible for the fact that the court was adjudicating the matter 12 years after separation. Now, there's two final points that I'd like, if I may please, to address. The first is the public policy in protecting the court's processes from fraud. In my submission, the outcome of the case before Sir Jonathan Cohen is highly likely, if one thinks about it, to encourage a person who was inclined not to disclose. What is the worst that can happen to that person? Well, if it's a valuable asset that they wish to conceal and they're found out about it, they just have to pay over what the court would have ordered them to pay over in the first place. Probably worth a try. If it's a valuable, if it's an asset that's gone up in value during the period, that's fine, because Sir Jonathan Cohen says it wouldn't be fair to share in the increase. So it probably doesn't matter if you don't disclose it in the first place. Now, in my submission, those are serious difficulties which Sir Jonathan's judgment creates if it's allowed to remain undisturbed. Now, I invite this court to indicate in its judgment that, just as in other divisions of the High Court, in the family division, the principle that no person should be entitled to benefit from their fraud is applied. In my submission, the court should indicate that where fraudulent non-disclosure delays the prompt disposal of a claim, the need to protect the victim's fair trial rights and the court's search for overall fairness is likely to lead the court to share the current value of the assets as at the date of the effective trial, notwithstanding any argument the fraudster might otherwise have to retain the benefit of post-separation accrual.
Well, this is getting close to say that the fraudster should always be penalised, but you accept in the submissions you're making that this has got to have the caveat that subject to the context.
Of course, absolutely. Absolutely. That's why I say the court should ordinarily weigh those principles. There may be circumstances which mean that that principle is not applicable. But in a case such as this, for instance, which we say is at the extreme end of the scale, certainly that principle ought to be applicable. Or the burden of showing that it isn't applicable should be borne by the fraudster and not by the victim of the fraud. Now, in our skeleton argument... So sorry, my lady.
So, I'm sorry to be slow about this, but I just want you to repeat it for my note, if you would. Please.
Of course.
So, you say in submission that the impact of Sir Jonathan's judgment in this case does potentially fail to deter a determined fraudster on the basis of either, one, all that will happen is that I will have to pay over the money I should have handed over in the first place, which in this case would be 2010.
Yes.
Because although we're now 12 years on, it doesn't really matter.
No.
Or secondly, that even if the court was to be persuaded that it should look at the situation as at the date when the fraud is finally exposed, that the court should then say, well, we take it from today's date, but we take into account all of the usual considerations of post-separation increase in valuations, and therefore I can still benefit.
Yes.
And in fact, I may persuade the court that my situation is so dire now that I could have lived 12 years in luxury, but now because my assets have fallen in value, I shouldn't make any more reparation to the wife. In fact, maybe she owes me something.
That's essentially the kingdom. What happened in kingdom? Yes.
So that's the kingdom.
Yes.
But you're saying that this court should be robust in saying that should not happen. Fraud should be deterred by the court making clear that unless the fraudster establishes good reason to the contrary, that the court should start truly de novo on the basis that the date for consideration of the parties' assets, responsibilities and the like is the date then before the court.
That's exactly what we're saying, lady, yes.
And, sorry, forgive me, and that on that basis, whilst the court must bear in mind all of the issues of post-accrual, the import of the husband in this case of fronting the company, the value of the company that's attributable solely to that, bearing in mind that we have a wife's share that may have contributed to it, that at the end of the day, what the court has got to say, but all the time, I bear in mind conduct. And I should never forget that conduct is a real issue because of the wife being a victim for 12 years, because of the injury to the court process. That's what you're saying?
Yes, and the third reason, because there was a very simple way out of this jeopardy for the husband, which was just to give full and frank disclosure in the first place. So all they have to do, and then all of these problems fall away.
Well, that goes into moral turpitude,
Yes.
because if he hasn't given full and frank disclosure, you're saying that you look at the reasons why and the degree of the compound deceit.
Well, it goes also to the charge that the husband might lay against my submission, that it's terribly unfair on him.
But
so insofar as that
your
is...
submission is that he's got the opportunity to do that
Yes.
before the court.
Yes, it isn't unfair at all, because it's very easy to avoid these consequences for you. That's my answer to that point.
Sorry.
Not...
Sure, thank you.
Oh, my lady, yes.
You've introduced into the discussion, and my lady's picked up on it, the question of burden of proof. You're suggesting that that somehow some burden on the fraudster to establish. Is that helpful? Isn't it ultimately just a question of the overall exercise my lady's been identifying without introducing... is it an evidential burden
Well,
of proof?
it's...
Is it a legal burden of proof? What are you saying?
I'm suggesting that through the formulation that I suggested a moment ago, that the assumption, the presumption perhaps I should say, will be in circumstances such as these, that the value of the assets will be divided as at the date of the delayed trial.
I understand all of that. I'm querying the usefulness and or appropriateness of introducing the concept of a shift of some burden of proof. For my part, I find that counterintuitive, speaking without having obviously considered all the arguments. But isn't it just the overall evaluative exercise by reference to the factors that you've helpfully been discussing?
Well, the alternative way, perhaps, of putting it is to say that the court is likely to weigh more heavily the delay and the wife's claim to the full value of the assets than the husband's post-separation accrual argument. At our skeleton argument, paragraph 18, which...
But, sorry, however you put it, do you say are you referring to an evidential burden of proof or a legal burden of proof?
A legal burden of proof.
Need to at all, Mr. Mitchell?
I'm so sorry,
Do we
lady.
need to get into the burden of proof at all? If the court, and my lady was referring to this, if the court has got an evaluative decision to make, then you put into the balance the husband's arguments, the wife's arguments. the court has got to weight those arguments as appropriate to the context.
That is right, although in some cases they speak of the person who seeks a departure from equality bearing the burden of establishing that departure from equality should take place in their favour. Essentially, in the family division, as your ladyship knows, burden of proof very rarely features in the way that it features elsewhere. And I don't intend to introduce, by my submissions, that burden into this sort of case. So I suspect we are just talking about evaluation.
So what you're saying effectively is if there is a case of established fraud, that which was usually incumbent upon the person who seeks a departure from normal principles should bear in mind that this is by reason of fraud.
Yes.
That goes back to conduct, which gives, as it were, a particular weight.
Yes. That's likely to be the overriding consideration.
Yes.
That's
thank you.
not at all. I'm sorry if I was unclear. A different point, which I will deal with now very shortly. So paragraph 18 of our skeleton argument is concerned with the application of the kingdom principle, page 82 of the core bundle. And we set out 5 principles which we say apply to kingdom. I can go through them, but they speak for themselves. And what all I want to say is that the other side criticise us for seeking to put a gloss on kingdom. But in my submission, we're not seeking to do that at all. What we're seeking to do by those 5 principles is to put in one place the judgment of this court in this case, the applicable principles which we have explored today and which are clear from the cases. I haven't put any gloss on this from our side. These are simply principles which are enunciated from the cases that we have already looked at. And in my submission, if followed, will always lead to a fair application of the kingdom principle in an appropriate case.
Do you wish to expand on those arguments that you've made in writing?
Not unless it would assist the court. There's just one qualification,
Yes.
or one addition. It seemed to me when I was rereading this that it was probably helpful to add a few words to the end of 5. So I would invite the court to add at the end of 5, or deprive the victim of her fair trial rights.
So this would become 5.23?
Well, I'd simply put 5. So the kingdom principle should not be available at the behest of a fraudster so as to permit him to benefit from his fraud or deprive the victim of her fair trial rights. Yes, paragraph 18. I'm sorry, my lady. It's page 82, paragraph 18. So it's just I've got numbered paragraphs in Roman numerals.
I was looking at...
Yeah, forgive me. I'm so sorry.
It's Roman numeral 5.
Roman numeral 5, yes.
Yeah, I'm sorry. I was
No, not at all.
catching up with my notes.
Not at all. Do you want me to repeat those words?
No, I don't. Thank you.
Thank you. Those arguments cover grounds 1, 2, 3 and 5 of the appeal, and that leaves just grounds 4 and grounds 6. Now, ground 4 is the failure of Sir Jonathan Cohen to properly weigh the wife's post-separation contribution to the welfare of the family. We deal with it in paragraphs 29 to 34 of the skeleton, which, like at least one of its authors, is a little fleshier than perhaps it should be. So unless the court would wish me to do so, I don't propose to expand upon.
So is this something you want to take up? No, we're happy to...
Thank you, my lady.
on the writing.
And you'll be relieved to know that leaves one ground, ground 6. I agree with my learned friends. That is essentially a portmanteau ground. Ground 6 is the result isn't fair. It is essentially a portmanteau ground, but...
Do you mean ground 6?
I do mean ground 6, I think, yes.
Because you dealt with ground 4 and 6 together.
I'm sorry, well, yes, ground 6, I've dealt with ground 6. I don't need to say anything further about ground 6 at this stage. Now, milady, is there anything that you would like me to deal with at this juncture that I haven't dealt with?
No, I think I've asked that which I wanted to during the course of the hearing, my lady.
No, thank you.
My lady.
May I just formally check with my junior and my sister that there's
Yes,
nothing
of
else they would
course.
wish? In that case, I apologise profusely to the court of my learned friend. I have gone over the time, I'm afraid, by I think about 20 minutes, factoring in the break we had. So I apologise to everybody for that. But I'm most grateful to the court for hearing me.
All right, thank you, Mr. Mitchell. Mr. Webster, do you follow?
I do, thank you, my lady.
Right, so, Mr. Bishop.
May it please the court. The judge, Sir Jonathan Cohen, when he was dealing with this matter, had the obligation under Section 25 of the Matrimonial Causes Act to take into consideration all the relevant circumstances. And he then had the discretion to attach weight to those circumstances which seemed to him right in order to arrive at a fair outcome. That is one that did justice to this case and met sharing principle and the needs principle. And in his paragraph 79 that we were looking at, it's clear that one fact became dominant in Sir Jonathan's mind, and we say rightly so. And that is the fact that the division of assets in 2010, which resulted in the wife receiving £7.25 million in cash and property, and the husband retaining CBA, that was a very important, indeed, determinative fact. And he highlights two very important points. The first, as he says in his 79.4, is that the division took place on the basis of accurate numbers, save in respect of the undisclosed trusts. If you look at what is said there, the value of CBA in 2010, which the husband had advanced, was verified by the evidence of Mr. Justice David Green in 2016, accepted by Mr. Justice Moylan, and never properly challenged by the wife. She never came to court and said, I've got rival evidence, either in 2016 or in 2022.
Well, she'd say it's because she didn't have the information at that stage to do so. That's the whole point of the set-aside.
I'm sorry to interrupt.
No.
I completely understand the wife's case is, well, the analysis of Mr. Justice Moylan in 2016 is undermined by the non-disclosure that took place in 2016, and I will come to address that to show that that's absolutely not correct, because the analysis undertaken by Mr. Justice Moylan stands completely independently of the question of the 2016 value of CBA. But it is a complete non sequitur to say that because the husband was found to have been giving a misleading picture of the value of CBA in 2016, that the evidence of the SJ in relation to 2010 value was undermined.
I think what is said, and that is something that I raised, as it were. What is said there is that you just can't be sure about that in circumstances where is it possible? Could Mr. Green's 2010 value have been affected in some loose way? I understand, not a technical way, loose way, by knowledge of the figures that were being offered in 2016.
Not if you look at it, and we can produce it, of course, but if you look at what Mr. Green does, he looks, as one might expect, at what the results were in 2009 and 2010. He researches and applies the appropriate multiplier from 2010. He comes up with his valuation at 6.7 million. And what Mr. Justice Moylan says in 2006 is, well, the husband was saying 6, Mr. Justice Moylan, Mr. Green was saying 6.7, that's within a reasonable margin of error, and therefore that element is reliable.
Yeah, so can I just ask you to address two things that arise at this point? Accepting what you say is obvious from Mr. Justice Moylan, as he then was, his judgment in 2016. Part of Mr. Mitchell's submissions to us today would be equally applicable to 2016, which is that in 2016, effectively, what Mr. Justice Moylan should have been doing is not saying, well, was the valuation in 2010 correct, but whether or not the clock should have stopped ticking in 2010, or should, by virtue of the husband's fraud, mean that the correct date of looking at matters was 2016. If that was so, presumably you would say, well, I can have no argument then. The fraud that was perpetuated by the failure to disclose on the day before the judgment the offer that had been made of 25 million for 25% of the shares revealed a new valuation. Could you argue against that?
What I would say is whether or not the 2010 division of the assets was something that was going to be left undisturbed in accordance with Kingdon, in accordance with H&H, which we'll look at, depends on an analysis of the objective fairness of that division.
Yes, and that goes back to the principles that Mr. Mitchell highlighted. Do you agree? The impact upon the victim of the non-disclosure, the impact upon the court process, the degree of turpitude in failing to disclose a significant revaluation, and finally, the benefit that would befall, inevitably, the person who did not disclose.
Yes, I'm happy to respond to each one of those now, if that's of assistance.
No, I'm just asking whether you accept that those are four correct principles for the court to apply.
When dealing with the substantive financial remedies case, my lady, the first of those, the impact on the victim of the fraud, that's relevant to the question of rehearing. That's not relevant to the question of distribution of assets upon divorce.
How can you divorce the two?
Because what happens is that if non-disclosure is established and materiality is established, then the matter is restored for rehearing. And inevitably, a costs award is made, as it happened in this case.
So it would go for a re-evaluation of the award?
Yes.
Right. So on that basis, if the court in 2016 had been aware of the offer that was made before judgment was handed down,
Yes.
and where discussions had been ongoing during the course of the proceedings, you're saying that the impact upon the wife could fairly be reflected by going back to 2010.
I'm saying that that particular fact would have made no difference to the basis upon which Mr. Justice Moylan determined this case and demonstrably
so. Can you
so.
be so sure? That's the point of my lady's
Well, I
question.
can go through that
Yeah.
probably this afternoon, but there are at least 5 reasons why.
Well, we'll go to that in your own time.
Sure, but coming to the other point. So the first point is the injury to the victim. Yes, that certainly justifies rehearing and cost penalty and unhappy delay as far as everyone is concerned.
So rehearing and cost penalty.
Yes.
That's the redress.
That is.
Yeah. Okay.
In terms of injury to the court process, again, cost penalty and indemnity costs, which is what happened in this case.
Right.
And of course, from my client's perspective, the fact that then matters were reopened and that there was no finality, which of course, it was his own fault, but that's a disadvantage that inured to him.
And how does the...
The third...
No. Can we just...
Sorry,
yeah.
yeah, of course.
So, Mr. Bishops, your submission is that the injury to the court process is mediated by a cost penalty.
Yes, remedied by that.
Yes, and if necessary, in appropriate circumstances, by reference to Attorney General or whoever.
Yeah, well, there could have been a referral
Yes.
in relation to perjury. But it could never be a factor for the division of funds on divorce.
Well,
It
what
can't-
about conduct?
Well, I mean, you know the authorities about conduct
Well, don't just say that, Mr. Bishop.
But better
You're sitting with
better than me. But
two judges. What is the impact of conduct? That's the question I'm putting to you in relation to a situation where the court has been injured using Lord Briggs's past phraseology, but also that there is a victim of fraud. How can that not constitute conduct?
the court cannot use conduct as a means of penalising a
I
party.
agree, but what part does it play in a case where there has been non-disclosure? Can it be, as you submit, put in any concrete terms, or is it all dependent on context?
It is, but also the litigation misconduct.
No, not talking about litigation misconduct. We're talking about the misconduct that results in an injury to the wife, in this case, or the victim of the non-disclosure.
Well, yeah, if there were to be an injury to this wife, we'll look at that more closely.
Of course, I'm just talking in general.
Then the court might want to see its award as remedying that injury.
And that would be part of the re-evaluation.
It would be part of a re-evaluation. But if the court determines that there's been fair sharing and complete fair sharing in the case, if that's what the conclusion it comes to, then an additional award based on penalising someone for creating delay or perpetrating fraud, we say would be illegitimate.
So I'm not as familiar with Section 25 as either you or my lady, but looking at the way conduct is listed, it's very, in Section 25, it's very widely drawn. The conduct of each of the parties, if that conduct is such that it would, in the opinion of the court, be inequitable to disregard it.
Yeah.
And it's counterintuitive for me, speaking for myself, to say that fraud in the context of non-disclosure would be irrelevant. You say it would be illegitimate to take it into account. It seems to me it would fall potentially fairly and squarely within the conduct that a court was obliged to have regard to under the legislation, and it would not be something that would be relevant only to cost penalties and the reopening aspect.
Well,
Am I wrong about that?
With respect, that would not be my submission as to how the courts approach the question of conduct.
Right.
There are authorities, and they were drawn to Sir Jonathan's attention, specifically disapprobating the use of conduct to impose a penalty for misbehaviour within the proceedings.
It wouldn't be a penalty. It would be this broad evaluative exercise, what's equitable and what isn't equitable, taking into account, I think it's common ground, delay can be brought into account, and the reasons for the delay and all the rest of it. Surely it's totally artificial to draw or take the fraud out of the overall equation of substance, not just procedure.
The determination of this case, I mean, if the court, as the court found, the fair sharing had taken place in 2010, supplemented in 2016, which we'll look at in due course, that satisfied the wife's sharing entitlement. She did in fact get an uplift in relation to her needs of £1.1 million.
Did either Mr. Justice Moylan, as he then was, or Sir Jonathan Cohen incorporate in their judgments their determination on the part that the husband's conduct had to play in their evaluation?
No.
No. So, accepting for the point of argument that you make, and which has been conceded by Mr. Mitchell, that we don't talk in terms of penalty, but we do talk in terms of an evaluation which takes into account all relevant factors of Section 25, and they're non-exhaustive,
Yes.
but there's specific mention of conduct. It's never been taken into account explicitly in either award.
No, and it's my submission that both in terms of Mr. Justice Moylan and Mr. Sir Jonathan Cohen, that was a matter for them to consider within their discretion. It was certainly argued that conduct should be brought into account before Sir Jonathan Cohen.
So that's the way you're putting it, is it? That it having been argued, and we can see it's been argued because it's in the skeleton argument.
Yes.
That in exercising his discretion.
Yes. He had the discretion to decide whether or not that was a factor that needed reflection within his award. And in circumstances where the wife was pursuing a sharing claim in relation to CBA in 2022, when he found explicitly that that had been satisfied in 2010 and by way of the enlargement in 2016, he was satisfied that there was no proper further payment due by reference to conduct, although it's fair to say, of course, that part of the reason why he makes a further payment in relation to needs of 1.1 million was in part to reflect the husband's, what he describes as turpitude. That's in paragraph 92 of his judgment on page 60.
Well, it includes H's turpitude.
Yes. But what he had, my lady, was a case where the wife was wrongly pursuing a share of a company which she had shared in fully 12 years before.
Before we get there, your submission to us is that unless we can say that in the exercise of his discretion, the judge failed it to take into account all relevant factors, then we must steer clear of any interference.
I certainly say that. I mean, I haven't gone through that because, of course, it's
No, but that's what you're saying.
I am saying that.
By stressing that this is a discretionary exercise.
He has the
providing
obligation
that he goes through Section 25
My
and
lady,
has regard to the jurisprudence.
Quite. He has the obligation to take all circumstances into account, and he has a discretion to decide which circumstances to regard as being most significant, to which most weight should be attached. We say that the exercise of the discretion in this case was not only within his permitted boundary, but was also plainly correct. And I'll move on to that now. The first one I said was because he said, well, as I started, he found that the 2010 division was of key significance. He found that it took place on the basis of accurate valuation.
Or accurate enough.
Sufficiently accurate, which wasn't adequately undermined by anything the wife did, either in 2016 or in 2022. And he found, very importantly, if you go back to paragraph 8, that what this had provided the wife with was a very substantial share of the 2010 assets. He said within the 2010 court process, H valued his interest at 6 million. There was no formal valuation. He retained his shares and director's loan account. The effect of the agreement, as I'm told, was the wife received 45% of the disclosed assets, although the arithmetic seems to me to produce a figure closer to 40%. I could deal with that if required. And the husband received the balance. No doubt his greater proportion, reflecting the risk and liquidity in the business, and perhaps, I know not, the origin of some of the funds. So, number one, he was satisfied the 2010 numbers were accurate. And number two...
No, sufficiently.
Sufficiently accurate.
Dependable.
Dependable, reliable, yeah.
Yes.
And number two, he was satisfied that that gave the wife a fair share in 2010, and on that basis, her sharing claim in relation to the company was satisfied. What she didn't get, of course, was the fact that any part of the not properly disclosed trusts. And that was a defect in the 2010 division of assets that was remedied fully in 2016. But save in respect of that one defect, there was nothing wrong with what took place in 2010. It was fair as to proportion. It was fair as to valuation. And it's the division which is the relevant thing. My learned friends go on about the order that incorporates the parties' division has been tainted by fraud and therefore can't be attached. But the actual division between these parties of the fruits of their partnership took place in 2010.
And you're relying on H for that.
Exactly, and I'm coming to that in a second.
Before you do, so far as the 2010 agreement was concerned,
yes,
it was an agreed order.
Yes.
Went before the DJ. Mr. Mitchell says this morning, well, look at what was subsequently found by Mr. Justice Moore, which was that, leaving to one side for the moment the valuation, that the husband had got another person to his way of thinking, Mr. O'Donnell, who was found to be totally unreliable and incredible.
yes,
So that aspect of the situation cannot be reflected, I'm paraphrasing him and I'm sure very badly, but that aspect of the situation can certainly not be reflected in a straight black and white division of assets, that you've got to put that into the balance.
the misconduct in doing so.
Yes.
Well, the misconduct in doing so led, of course, to the set-aside and the costs. But
he's talking about the misconduct and the impact upon the award. So he's saying it wasn't just a matter of figures, and that what Sir Jonathan did that was wrong was thinking that it was only about the bare figures involved. And he hadn't looked behind those black and white figures. And that's why he says that the turpitude was not recognised to its full degree.
And that's, I'm afraid, I disagree with him about.
Well, that's why I'm inviting your submissions, because we are asking these questions. You do realise, Mr. Bishop, but I say this so that both the husband and wife understand we're testing the cases on both sides.
Of course. But
so I need you to answer that point.
When this took place in 2010, the division that took place in 2010, which left the wife with, we say, 45% and very little risk in terms of the assets, that was objectively fair. And it didn't become objectively unfair because of the way in which the husband conducted himself at that stage. And the defect and the non-disclosure that the court, that Miss Justice Moore found, was remedied in full by Mr. Justice Moylan in 2016 by granting the wife an additional 6.42 million. My own friend said in one of his sort of parting points, oh, well, this is all a great encouragement to fraudsters to try and get away with it. What in fact happened was, if my client had made a disclosure of the trusts in 2010, those would have been shared with the wife and she would have got about 2 million. In fact, 6 years later, she got 6.42 million because she was then entitled to a share of the growth in those trusts that had been generated in relation to various trusts. So she got the first, chapter 1 of her fair sharing, including in relation to CBA in 2010, and then the defect was remedied in 2016.
Yeah, but it was remedied in purely, dare I say it, financial terms. But was it remedied to reflect the turpitude, but which by then was known?
Well, the turpitude caused my client to have to pay a further much higher sum than would have been if he had fairly divided the assets, honestly divided the assets in 2010, because he didn't pay 2 million, he paid 6.42 million. And also, of course, he had a huge cost liability and a further process of his own costs as well. And so the degree of turpitude as being a factor within the evaluation of a claim, it's exceptionally rare for conduct to feature as a factor, and it needs to be justified. And if it can't be justified by reference to imposing a penalty upon a fraudster, what is the justification?
So is your point this, that in 2016, by making, for example, the indemnity costs award and the wife recovering a greater sum than she would in 2010 terms, whether designed to or otherwise, the turpitude of the husband was reflected in ultimately the figure and the costs that were made? Is that it?
Certainly. And turpitude, we're going to have to look at turpitude in a moment in Kingdom.
Do you know what else we're going to have to look at, Mr. Bishop? We're going to have to look at the conduct cases that you're referring to very generally.
Yeah.
So perhaps Mr. Sear, over the shorter German, can start to collect together, with your obviously overview, those authorities that you want to put before us, because you've just made a very, very bold submission, if I may say so, to my lady, which may be right. But I think that instead of just referring in general to these conduct cases that don't support any particular weight being given to conduct in such circumstances, you should substantiate that.
Yes, I agree with that, and we will do so. And I apologise that they're not before the court. I mean,
Mr. Bishop, don't waste time with apology. We can sort it.
on we go. Just to mention, before Sir Jonathan Cohen, in fact referred to in the skeleton, which is within the papers, are the authorities.
Yours or?
Ours. The
Yes.
authority that says that it's no part of the court's purpose to penalise.
Yes, this is why I drilled down with Mr. Mitchell, obviously, and you've heard what he's had to say about that.
Now, what is said by my learned friends is that it is impossible for the court to look at the 2010 division and assess its objective fairness. And we respectfully think that that's just not right. It was perfectly possible for this judge, and indeed for Mr. Justice Moylan before him, to look at everything apart from the trust and to assess the fairness of it. He could see what each party got. He could see the composition of their exit funds. He could assess whether the assets were liquid or illiquid. He could calculate the percentages of the whole, excluding the trust. This presents no difficulty at all to the judge. And so he was in a position to undertake that assessment of objective fairness. And the conclusion he arrived at was that the wife had received her fair share of the company upon separation by way of the 2010 division. If that's right, it's inevitably the case that she's not entitled to another share. You only share once in the fruit of the partnership. That's the point about the collapse that that Sir Jonathan Cohen is making at 79.6. And that is, if CBA had collapsed in value, the husband couldn't come back to court and say, well, I'd like to...
Which paragraph are you referring to? Because my paragraph 76 isn't that.
79, 79 Roman 6. That's within his sort of his disposal reasons. What the relevance of this is that if CBA had collapsed in value, Mr. Goddard-Watts wouldn't be able to come back and say, well, I'd like to revisit the sharing of the cash. Because once these assets had been shared, that was that for both parties. We don't know of any authority where someone gets 2 shares of the fruits of the partnership.
Well, that's because, as Mr. Mitchell says, that there have been no authorities on this point, which is why Lady Justice King, in part, gave leave. So, it's not sufficient to say, I know of no authority.
Very well, my lady, I withdraw that. That's not helpful.
This is what we're here to look at, isn't
but
it, Mr. Bishop?
Understood. But the proposition is that if the fruits of the partnership have been shared in an objectively fair way, they shouldn't be shared again, whether there's change of values or collapse or for any other reason.
So may I just ask a question there?
Of course.
What you are positing, and that which Roman numeral 6 in paragraph 79 refers to, is a case that is free from taint. We're dealing specifically, are we not, where we have to consider whether the interception of non-disclosure, fraudulent non-disclosure, then takes the case from the ordinary route along another road.
Well, possibly. But, of course, Sir Jonathan Cohen knew the full history of this case. He records it all in the early parts. He's under no misapprehension at all about the fact that there had been 2 rounds of non-disclosure. So he understood. But by the time it came before him, it was no longer a taint case. Taint case refers, in my respectful submission, to the process of rehearing. Set aside and rehearing. If it is tainted by non-disclosure, then there will be a rehearing. But at that rehearing, the fact of the taint, the non-disclosure, doesn't justify further money. The justification for a further payment has to be in line with Miller, Section 25 of the Matrimonial Causes Act. That is, it's justified by reference to sharing or to needs or compensation. And so by the time the matter was back before Sir Jonathan Cohen for the disposal in January of this year, the non-disclosure, subject to clarification of the point about conduct, which we'll look at, the non-disclosure was not a relevant factor anymore. What was relevant to look at was whether or not this wife had a residual sharing claim or a residual claim to meet needs. And the fact that she had shared fully, as I say, by reference to 2010, enlarged in 2016, that was fatal to her sharing claim.
Sorry, I've made a note. You said by the time of the rehearing, the fraud was immaterial. Is that basically what you're saying?
Yes.
But that just can't be right, because at the rehearing, the judge had to decide whether he was going to use the flexible case management procedure offered by Kingdom, or whether to continue, or whether to start from scratch. And to that was part of the decision he had to take.
Yes.
And on that decision, then surely the fraud was directly relevant. Am I missing the point?
think that-
Relevant in a different sense.
It might be a misapprehension, my lady. The fraud is relevant to establish the right to a rehearing. At that rehearing, the judge can decide whether or not, on the facts of the case, all the facts of that case,
How to proceed?
how to proceed.
Yes.
And that isn't. The fraud at that stage is in my submission, is no longer relevant.
Well, it was clearly front and centre of what was put before the judge.
It was.
And he took account of it.
And he
I'm
took
just
account of it.
Yes, I'm just looking at his judgment. He refers to it in paragraph 88.
Yes.
He makes the point, as Milady has alluded to, that he states that he's conducting a rehearing. He says, I must determine what is fair now, must do so by reference to all the circumstances of the case. These include the current resources available to the parties, but also the division which was effected in 2010, and that's in italics, the fact that this was procured by non-disclosure.
Yes. Yes. So he is looking at everything de novo. He is considering the whole picture. He is evaluating all the circumstances. And his evaluation was the most important fact is that this is a wife who has already shared fully in CBA at a fair value as part of a fair overall proportion, and then shared fairly in the trusts in 2016. But the determination of whether to go down the Kingdon route or a different route, my lady, we say that that was absolutely, again, a matter for his discretion. He was entitled to decide what to do. It wasn't a situation where the wife's trial rights were curtailed in any way. It was a full hearing with complete updating disclosure. But having heard all of the evidence and all of the submissions, this judge decided that what had taken place in 2010 and 2016 satisfied the wife's sharing claim. And it wasn't only, we say, within his discretion, as I say, it was correct. And we point to three things that indicate that that was the correct approach. Do you want me to start that part of my submissions now?
I don't think I do. I'd rather have the three all in one.
Well, I'll give you the headline. Firstly, that it was consistent with what Miss Justice Moylan had done. Secondly, that it chimed with the approach in H&H. And thirdly, it was entirely consistent with the principles put forward in Kingdon.
And you are supporting all of those three reasons?
Those three reasons I submit are three indicators why this judge got it spot on.
Yes, that's what I'm saying. You are supporting those three reasons for
certainly
taking
am.
the course
Yeah.
you did.
Yeah.
All right. So I think that would be a convenient moment, Mr. Bishop.
Yes,
We'll start again at 2, if we may.
certainly.
Thank you very much.
And we will find the most pertinent authorities in relation to conduct and supply them in hard copy.
And I'd like you to liaise with Mr. Mitchell and Mr. Webster, obviously, about that.
Certainly.
Because they may have a different idea about what the most relevant.
Of course, yeah. Well, I wouldn't be hiding any which weren't relevant.
No, of course not. Of course you wouldn't. But no, of course you wouldn't, Mr. Bishop. I'm not suggesting that for a moment. But you know
Yeah, but there can be a question of judgment in relation to that.
Yes, right. Evaluation. All right. So 2 o'clock. Thank you.